right, it's just those three, Kenya, Somalia and Swaziland. Somalia's is very limited. It's a case of necessity, especially to save the life of the pregnant person, whereas in Kenya it's emergency, risk to life and risk to health, and in Swaziland there's a longer list around serious risks to physical and mental health, a serious risk that the child would, and please accept the language, this is a quote, be irreparably seriously handicapped, and in all those cases one doctor certifies, and no, as far as I understand, medical certification is required, but I don't know whose certification is required in cases of rape, incest or unlawful sex with, and again this is a direct quote, a mentally retarded woman. Both the Kenyan and the Swaziland provisions, to the best of my knowledge, are relatively recent, within the last decade, and in neither case has legislation been passed to give effect to them. So in both states, in fact, abortion is largely inaccessible, and my understanding is that the UN Population Fund and other organisations document extremely high levels of illegal abortion in those jurisdictions. As regards other European states and constitutional courts, there are some courts that have dealt with similar issues. It's perhaps particularly interesting to talk a little bit about Slovakia, the Slovak Republic, because in that jurisdiction there is a recognition that prenatal life is worthy of protection. But not a right to life. And the way that the court has dealt with that is to say that regulation of abortion is permissible, but that you cannot disturb the essence of the rights that women hold under the Constitution. And that's not wholly dissimilar to something like the approach in the US Supreme Court, which is to say you cannot place undue burdens on women in accessing abortion, or a proportionality. There will be degrees, of course, of whether an essence is less or more than a proportionality approach, but that kind of approach is, I think, relatively common. It might be worth noting that the German Constitutional Court, relatively early on in its jurisprudence on abortion, did recognise the prenatal right to life, but has progressively accepted that that does not preclude making abortion available within certain schemata or under certain limitations. And the constitutional courts, and this is my understanding of the list, it may be longer, of Austria, France, the Netherlands, the Slovak Republic and Portugal have all refused to recognise the constitutional prenatal right to life. Was that all your questions for me?
I believe so.
Okay.
I believe so.